Be seated, please. Welcome to the survivors. Our last case today is Shannon Medical Center versus Sickels and Cole. Who's present for appellant?
David Walsh.
And for, I'm sorry. Are you all splitting time or? No, that's all right, please, but please, we'd take an announcement so you can get credit for it. Thank you. And
It's Kyle Dreyer on behalf of,
all right,
and along with me is Josh Flippin and Matt Keita. We are not splitting time unless, of course, the
Good.
board asks something that I don't have an answer.
right. I doubt that. You may proceed.
May it please the court, David Walsh with Anna Romano for Shannon Medical Center. I was in the hallway during the other cases, and I just want to say, you've been through a lot today, so if you would, I would rather you ask me whatever you want to know than me give prepared
Whatever we
remarks.
have left in us.
Correct. I have some prepared things to say, but I'd rather just answer your questions. So as I was thinking about this case in the hallway, this is the case we're saying is a healthcare liability claim. And one of the reasons we're saying it's a healthcare liability claim is it's a safety claim that has a substantive nexus to healthcare. And I look at the Ross factors and I say, what are we trying to protect there? And we're looking at, is the patient potentially in harm's way? And if you look at the facts of this case, the location, radiology department, where the patients might be, you have claims by people that are in the radiology department where patients might be, and you have a device that's used in treating patients in the radiology department, the X-ray machine or CT scanner. And if one of them is emitting more radiation than it should be, that would seem to put patients in danger. And under the Ross factors, however we want to slice and dice them, that's the very purpose of Ross, of looking, is this a place where patients can be and patients could be harmed by what they're saying? And that, I think, is this case. And so,
But is that asking us to assume too much? I mean, I'm not an expert on radiology doses, but I assume that there might be a difference between a patient coming in for a one-time X-ray who's got a broken arm, that's the only X-ray they have in their life, versus, standards that might be more directed towards protecting, people who are there every day.
sure, except for
Sure.
we don't know the dose leak, if it's a leak. So I view this
Yeah.
as two ways, one of which they talk about the machines are emitting more radiation than they should, which I equate to a leak, which
Yeah.
would overexpose the patients and make them susceptible to cancer on top of the one X-ray that they got. Because sure, maybe one X-ray isn't enough to cause cancer, but maybe the machine is leaking enough to cause that problem. Or that's increasing their lifetime risk of cancer, because if you have enough X-rays, there is a lifetime risk of cancer, so the patient is back in harm's way. So I don't think it's really asking to assume too much based on what they've alleged about overexposure to radiation, because the patient is in the same harm's way as Sickels and Cole.
Does it affect the Ross factors at all that the statute they've actually sued under for radiation exposure does not, I think it excludes claims by patients?
It excludes treatment is what it's excluding. Basically, the statute's saying we're not practicing medicine. If a doctor wants to prescribe dose X, we as the statutory, I think that's in the regulations, but we as the radiation board are not quibbling with what the doctor and his standard of practice view. But this is where it gets back to, it's not a treatment or lack of treatment standard. We're talking about the safety standard. And if it's causing overexposure to radiation, that's the problem with why it's related to, has this substantial nexus to healthcare, because in going to get the treatment that they're not controlling, they're getting overexposed by what they're alleging the hospital did or didn't do. And that's why it's the substantial nexus, and why I think the Ross factors come out this way regardless of whether patient treatment is involved. And indeed, we know from, sorry, I'm blanking on the case name, give me just a second. Coming Attractions, they made it very clear that the statute was broadened from patient to claimant to make it very clear that it doesn't have to be the patient that's involved in the treatment. And so when we get to what they say about the regulatory statute is they say things like, it applies to the oil field, it applies to other places that might have it. But when you apply it to a hospital, who are you looking to protect? You're looking to protect the workers and the people in the building getting treatment. And so if there's a radiation leak there, it exposes the patients just as much as it exposes the workers. And the second thing I'd say about that is the next part of coming attractions is about what happened, right? That's the Ebola case. And so they let Ebola out of the building, expose the business in Ohio, and that's the same thing that's happening here is you're letting radiation go where it shouldn't go, even if it's just in the building, you're letting it out. And that is the very virtue of, or the very nature of healthcare, like letting Ebola out of the building. So,
On the issue, if we could look at the employment question, are the Limestone and Stevenson cases in conflict? And if so, how do we reconcile that?
I don't think so. And I'll start with one particular reason. The Stevenson waste management case, right, is really, it's a staff leasing case. This isn't alleged to be staff leasing.
Yeah, it's a totally different fact, but.
Correct. And while I think that there are some interesting things in Stevenson that you might look at and say, well, we look at the facts on the ground. Well, you're looking at who's got control, right? And what is the manner and means being controlled? And if you look at their affidavits, they don't say, I was an employee of the hospital. They don't say, I was controlled by the hospital. They have this other little dance around stuff of, I received some training from the hospital. All doctors receive some training from the hospital, right? They have to know how to use the machines.
Yeah, but the machines are a big piece, right? And then there's also the scheduling.
Except for, it's no different than how you do an OR schedule for the operating room, right? The surgeon isn't under the control of the hospital because they say, show up at this time to do your procedure. Same thing with scheduling for the department, right? We've got to get these patients in at a particular time, but it doesn't control the two things that I think are what a radiologist are doing. They're reading films, right? How does that control how they read the films? Because scheduling doesn't even tell them the order that they read the films in. They read films. Then the next thing is they're doing interventional radiology procedures. Well, they're not telling them how to do the interventional radiology procedures if you take their allegations. They're just, or I'm sorry, not their allegations, their affidavits. There's nothing in there about the manner and means by which they were exposed to radiation. And that's when we look at manner and means from Stevenson and the other case whose name is escaping me that you mentioned.
Oh, Limestone.
Yeah, Limestone, is you're looking at the manner and means of what caused the injury. And so what do they say about manner and means of injury causation? There's nothing in those affidavits. It's all a bunch of vagaries of things that you do between a doctor and the hospital where they have privileges, where they have to collaborate to some extent so that they can run a medical facility. And so that Shannon Clinic and its doctor employees are coordinating or working with Shannon Medical Center so that the health system can run as a whole. That's not surprising. That happens in every medical system that there is. There has got to be coordination of care so that we have people doing what they need to be doing. But it doesn't control the manner and means by which it's done. So it schedules, we can go to OR6 today because OR6 is available for your procedure at this date. But you can't go tomorrow because we already booked that for somebody else. Same thing with radiology workflow. It's the flow of the radiology department. We've got to get all the cases through, all the people seen, all the films read, all the interventional radiology procedures done. It's all just a coordination of care, but it's not the manner and means by which they do their job. And that's the mental part of being a doctor and thinking about the case, or the physical part with their hands of actually doing the interventional radiology procedure. And there's nothing in the affidavits about controlling the manner and means by which they do their work. And that's why I don't think it meets the employment thing, particularly when the record has their employment contracts, which even in their affidavits, they admit we have signed employment contracts with Shannon Clinic. And so how with the vagaries of things that aren't manner and means by which they're actually doing their job as a radiologist, how does that trump the employment contracts, which very clearly is an employment contract with Shannon Clinic? And if we look at another factor, payment, the only evidence of payment is in the contracts, and that's them getting those WRVUs, which is a medical mumbo jumbo for some work productivity thing of how much we make and how much you'll get paid out of that. But that's how they're getting paid. but by Shannon Clinic, nothing by Shannon Medical Center. And so while the instrument, you could think the instrumentality, oh, that's the x-ray machine, except for it's not. The instrumentality is actually the doctor looking at the film and saying, you've got this disease process from that, and that's not controlled at all by Shannon Medical Center, at least according to the affidavits. And so vague things like, we got training and guidance, we talked to the chief medical officer or the chief executive officer, none of that discusses how that's manner and means of doing their jobs, and particularly as they're exposed or overexposed to radiation. And that's why I think that that's just the problem with this case, for that perspective of employment just doesn't seem to fit the bill with what they're doing. While they've alleged it as a non-subscriber case, it doesn't seem like it's a non-subscriber case when you have their own affidavits, don't say anything about controlling the manner and means, and you have these employment contracts. So how is it within the exception? And then when we go back to, well, okay, so what does that mean for you, David? And I would say, well, that means that they can't artfully plead around Chapter 74 then, which is what we look at it as, is this is just a manner of artful pleading to get around the healthcare laws. And that's our trouble with this case, is because they work for somebody else, Shannon Clinic. How are they working for our employees under our control of the manner and means of their work? And if they're not, then they're just using this allegation of of the non-subscriber thing to get around the statute that we were entitled to a report for. And since they don't have a report, they just have medical records, and they don't even defend that the medical records in this court, they don't defend that the medical records constitute a report, that requires dismissal. Keep in mind, if there was ever doubt 74-353 existed at the time of this claim, they could have said within 30 days of us answering, hey, this isn't a healthcare, trial court ruled that this isn't a healthcare liability claim, and we could have had a debate about that before the expert report requirement expired, but now it's expired and you can't go back. And even under 353, if the trial court gets it wrong and says it is or isn't, that can be appealed. But more importantly, the expert report requirement doesn't expire until after that determination has been made. And if it's determined, then they get 90 days to get an expert report. So they had an out that they could have used but didn't in this case. And so with it not being employees of the hospital and with this substantial nexus to healthcare, I look at this as an expert report case that they didn't have an expert report on.
Does that mean the lion's share of workplace injury claims by doctors who work in hospitals are going to come under Chapter 74?
Again, I think it would depend on employment question, and then I think it would depend on what their workplace claim is, right? So I'm just going to assume that they're not employees for now, but is it a slip and fall in the hallway? Is it the patient went crazy and beat me up in the hospital and you should have had him restrained? There could be varying levels of what it is. So I think to not answer your question appropriately, I think the answer is it depends. Is there a substantial nexus under the Ross factors or not?
Well, it's just you're always trying to think in our shoes, you know, if we go this direction, what happens in the next case, and the next case, the next case? And that's a ripple effect, as I was listening to you, that I could see happening, is that we, in some ways, make
Yes.
super incredibly hard workers' compensation for doctors.
Except for doctors generally don't, generally, doctors don't work for hospitals, and we talk about the corporate practice of medicine doctrine, but hospitals are really earnest about trying not to do that. And so they set up these separate things like Shannon Clinic, which is its own corporate entity. Even if it has the same executive officer or whatever, it still follows its same structure, and they've done nothing to try to pierce the veil of Shannon Clinic to say that it's Shannon Medical Center. But even if it was, they're brother-sister corporations that probably would go back to the health system if you're piercing anything. But they've not even made that allegation. So that's, to me, the answer to this is most doctor claims are never going to make it here because they're not employees of the hospital. Because it's late in the afternoon, unless you have more questions.
There's no shame in waiting a minute and a half.
Okay, now I'm going to take no shame and sit down.
Mr. Dyer.
Thank you, Your Honor. May it please the court. I'm going to address this. While there are a number of instances where there is a waiver of arguments, both at the trial court and within this court. I'm not going to address those because I think the heart of this case is in the substantive issues that have already been discussed. And it's for this court to decide those substantive issues for the benefit of doctors and others in hospitals. There are two real issues, and they are intertwined here. The first issue is this is not a healthcare liability claim because these doctors were employees of the hospital doing the work, and the work that they were doing by statute and by administrative regulations was in the power and the control of Shannon Medical Center. That's what 289, 227, and 289, 231 says. It says that it's the licensee here, and there's no contest that these are the licensees, these are the registrants for the use of the equipment in the hospital that emit radiation. It's more than x-rays, it's fluoroscopies, it's a whole host of different things that are in this record. And it is the responsibility of the hospital to control the radiology department and the machinery that's in there. They are the ones that are obligated by Texas law to make sure that that equipment is well taken care of, that they monitor the exposure of the workers, not patients. And in fact, 281231 specifically says, not what counsel says, but if you look at the language of that particular provision in 289231, it specifically says, I'm sorry, not 231, 227. Hold on a second. It specifically says that it excludes exposure to patients who are being cared for or treated. Why is that? Because by statute and by administrative regulations, the rules are there to protect workers, not patients, because it's the cumulative dose. That's what the administrative regulation says. It's the cumulative dose that affects those workers. That's what they say. So if you think about it in the context, we submitted affidavits saying we work full-time at the Shannon Medical Center Radiology Department. We got paid based upon the number of people that we treated there or the number of activities that we did, whether or not a patient is present. Patients are not, and there's no evidence that they can offer that patients are always present in the X-ray room. They're not, because some of the X-ray departments are looking at tissue where patients are not present. So the administrator said, let's make sure that we protect workers, not just in the health field, but in the oil and gas field, in the nuclear industry, the veterinary industry, at colleges and universities like the University of Texas. And we're going to place responsibility for that monitoring, and we're going to place responsibility for making sure that workers are not overexposed. We're going to place that responsibility on the registrant, and the registrant here is none other than Shannon Medical Center. So they had control over the very activities that were being done by these doctors in the radiology department. And the law imposes upon them, and they can't abdicate that responsibility to the doctors. It's their responsibility to protect their workers. And let me just say this, and I want the court to understand. I think you have to read all the statutes together to make sense. And we know that in Texas, we should not ever read a statute in a way that provides an unjust or unreasonable result. That's exactly what they want to have happen here. And let me give you the reason. A lab technician works in the radiology department and is directly employed, because they can employ lab technicians. By rule, they don't employ doctors. Why? Because they don't want to be responsible for the independent judgment of the medical doctor and under a respondent superior theory. That's what they say, okay? So, but they can employ lab technicians. The lab technician gets exposed working in the radiology department to an excessive amount of radiation, and the lab technician does not have a health care liability claim, but the doctor has a health care liability claim. Is that just? Is that reasonable? Or is that absurd? And the answer, in my view, is it's not just, it's not reasonable, it's arbitrary. It's arbitrary. Why would a lab technician, the responsibility is to protect not just the lab technician, but anybody working in, by definition, under the administrative codes, anybody working in and around radiation emanating equipment, and you have the responsibility to monitor, you have the responsibility to provide protective equipment to your people working there. Not only that, but you have the responsibility to train them, you have the responsibility to post notices for workers, not patients. It's all delineated in 289231 and 289227. There's a host of responsibilities placed upon Shannon Medical Center because they're using ionizing radiation. They have the responsibility to do that.
On the point about workers and the employment issue, I wanted to pose the same question I asked your opposing counsel.
Yes?
Are the standards in Limestone and Stevenson different, and does it matter which one we follow?
You know, when I look at that, I've got to tell you,
Yeah.
I'm not a appellate lawyer by training, but, and sometimes I would look at it. When I was in law school, I remember there was a professor that asked a question, and one of the students was there, and he didn't know the answer to the question. He whipped out his wallet, and he says, "Kirk to Spock, beam me up." Okay, and I'm not in one of those moments right now where I felt like I need to be beamed up.
Sure.
Okay, but I will say that I think a couple of the cases that they did cite on this issue of the independent contractor are instructive, okay?
Sure.
First, they use this, I think it's a case called Farlow, right? They say, well, the contract's a control, but Farlow actually says, no, you still need to look, not just at the language of the contract, but I think you need to look at who is exercising control, and it's not what the doctors here were doing, it's what the hospital was doing when you're looking at control. And then when you go to the next case that they cite, which is called Redinger, it's not in a medical liability context, but when you look at Redinger, Redinger was a case where there was a general contractor and two subcontractors. And the owner of the property, the general contractor was an independent contractor and the subcontractor was an independent contractor. Well, the owner of the property said, I'm not controlling the means and manner of what they're doing, but the court said, well, wait a minute. You stepped out that morning and you told your general contractor to move the pile of dirt. That's what you told them to do, and to move that pile of dirt now. So that owner took control over that, and guess what? The other independent contractor was hit by the general contractor. Well, here we need to look at who has control. Who has control over what we are alleging here? And the entity that has control by statute, by administrative regulation, the entity has control and is obligated to follow the monitoring procedures, the protective equipment procedures, the notice procedures, and all of that is SMC. And so they have control over that. So to that extent, do they have control over whether the doctor reads the x-ray correctly? Well, no, but that's not the allegation here. The allegation is these doctors were hurt by what SMC was empowered to control and by statute had to control, and they can't abdicate it. Let me also say one other thing about the unjustness of it, and that is, why is it that an oil field worker working for a non-subscriber who the obligations for exposure to the oil field worker are identical to the limits of exposure for these doctors and the lab technicians and others? Why is it that a doctor who's working in a hospital simply because they're working in a hospital where patients may be present is going to be burdened by the procedural requirements of the Health Care Liability Act and the damage limitations of the Health Care Liability Act when the oil field worker, the nuclear worker, the worker in the veterinary, the workers over here at the University of Texas doing research, anywhere else there may be radiation in the state of Texas, isn't burdened by either one. Is that just?
Well, since we're talking about what's just, talk about the coming attractions case. I mean, that's one
Yeah,
that's.
and here's the difference, Your Honor, and I would appreciate, and I do appreciate you, and I was going to go straight there, but here's the deal. The coming attractions case did not involve an administrative code specific to radiation. Instead, it was a virus. And as we all know, viruses, and what was acknowledged by the coming attractions case is the virus are spread or can be spread to other patients unless you have appropriate procedures in place to protect the spread of the virus in your hospital. That's what they said, okay? Radiation is not a virus. Radiation is, if I'm going to get cancer, and these people lost, they were radiologists, and they lost digits from the cancer in all of their hands and can no longer work. Radiation is not a virus. It is caused by the exposure to that ionizing radiation that's being emitted from the very tools that SMC is responsible for. And it's being emitted by all of those pieces of equipment for which they are obligated to monitor and make sure that their people aren't overexposed such that they receive cancer. They did not. Right? It's not patients, it's for the benefit of the workers at the hospital. And there is no question that these doctors were workers at the hospital where the ionizing radiation equipment was located. And so whether you look at it from the standpoint of employment relationship or you look at it from a substantive nexus, and you can decide the case on either basis. If you don't want to address the issue of employment, it's no different when you look at it from this substantive nexus, okay? There are really two essential elements that they've talked. We got 7 in Ross, right, when it's a safety-related claim. But when you look at all of the lineage of cases afterwards, it really comes down to whether the action complained of is substantially related to the provision of health care for patients. That's what they say. Is it really related to that? And then the second thing that they really go off on, it's not even one of the 7 factors, it's the 8th factor, I would call it, and that's the need for expert testimony, right? Is an expert needed? Well, the answer here is yeah, an expert's needed, but not the expert that is called out specifically in the Healthcare Liability Act. In the Healthcare Liability Act, the expert for a claim against a healthcare provider, and I want to make sure I quote the language correctly, the claim against a healthcare provider has a second element, and that second element is, I got to find it, has knowledge of accepted standards of care for healthcare providers for the diagnosis, care, or treatment of the illness, injury, or condition involved in this claim. Okay? We are not making a claim at all about the diagnosis of their condition. I would say their own doctors, SMC's own doctors, are the ones that diagnosed them with cancer because of ionizing radiation exposure. Okay?
So what type
But-
of expert would you normally use? in
Would
this?
I use in this case? And this is exactly what I told the trial court. We would need 2 experts. And in fact, we've already reached out, but you'd have to have 2 experts, right? Probably 3. I'm not saying you don't need a doctor. You don't need a doctor to say, this is skin cancer, and it's basal cell skin cancer, and basal cell skin cancer can be caused by radiation. But to get to the liability aspect, we've got to show that they were overexposed because of Shannon Medical Center's failures, and that failure could be you didn't monitor them appropriately, right? You didn't check to see whether their radiation exposure exceeded the allowable limit for workers in Texas, and that's going to be in engineering, human factors. Those are the kinds of experts that you're going to need to be able to establish that liability. What should people working in and using radiation do to protect their employees? It may be a former OSHA person. The people that advertise in this arena, to answer your question, none of them are medical doctors. They're engineers who have designed and implemented, at the request of hospitals, ways to minimize exposure to workers from radiation. That's who's out there. You can Google it. That's who you find. Those are the people, and those are the people that we need to have. And not a medical doctor to prove liability, not a medical doctor to prove the liability relates to as an approximate cause of the injury, although we would probably have to have somebody in the medical community to talk about the effects of radiation on the skin, basal cell carcinoma, but not with respect to the liability and the other causation issues. Okay? So if you want to, and I'm going to be like my esteemed counsel, and I'm going to give back some time, but if you want to do in here what's really right, what makes the most sense, then you give full effect to what the Radiation Control Act and all other pieces of legislation that go with it, the administrative rules and regulations, you give effect to that. And you place upon hospitals and you place upon others in the industry the responsibility to follow those administrative rules and regulations to make sure that their workers are not exposed. And I can't emphasize enough that what we complained of in our argument under the scope specifically excludes, without any shadow of a doubt, it specifically includes measuring doses for purposes, measuring exposures to patients, because that's not what we're concerned about. We're concerned about that cumulative dose, not the one-time dose. Even though counsel, without any background or expertise, makes that suggestion. Well, the statute says otherwise. And in fact, many of the provisions in the administrative codes and administrative regulations apply only to workers, not patients, and not even the public at large. That's what we're complaining of, their inability or their failure to do those things to protect their workers in their work environment. And I stand prepared and ready to answer any questions that you may have, but I hope I've addressed the issues.
Thank you, Mr. Dreyer. Rebuttal?
I'll try to be brief, but that's not my historical nature. Let me start with, what did I write down as number one? X-ray, fluoroscopy, whatever it is, if you're overexposed to it, you're overexposed to it. So if it's leaking out to hit the doctor, it's leaking out to hit the patient, right? And so that's the problem with their argument is they focus
But
on.
here we don't actually know what the machine was, right?
And we don't need to because we know it's in the radiology department and the equipment that they're used to treat patients. It's not like in McNew, they didn't know what the source of the radiation was because they didn't even know that it was coming from the radiology department. Here we know because they've alleged they worked in the radiology department, and so we know it's X-rays and CTs and fluoroscopy, and fluoroscopy is just a fancier X-ray that shoots in real time as opposed to shoots a one-time picture. So it's all the same technology and all the same equipment, and so we don't need to know that it's this particular machine because we know that's what's in the X-ray department or the radiology department that emits X-rays. It's CTs and not MRIs, CTs and X-rays and fluoroscopy, but it's all X-ray technology. The second thing I want to say here is when we get down about fairness and whatever, the last thing I think anybody could say is that the healthcare statute's fair to anybody, but that's not what the legislature envisioned when it wrote the statute because it wanted to help out healthcare providers, but that's their prerogative and has not been found to be unconstitutional just because it's some unfair line drawing that we're going to treat doctors who don't work from the hospital differently than the lab technicians who do work for the hospital. And there's an important distinction there because the lab technician falls into the exemption in the definition of a healthcare liability claim, and the doctor, who's not an employee of the hospital, doesn't fall into that exemption. And that's a line that the legislature drew after the Texas West Oaks case because it wanted to make sure that employees of the hospital that might have a workers' comp or non-subscriber case didn't fit that problem. The problem is the doctor just doesn't fit into that definition because the doctors don't work for the hospital, they work for Shannon Clinic.
Could you address the point he made about the type of expert you would need here? So what would an expert doctor?
Doesn't have to be a doctor.
Well, that's my question. I mean, what type of expert would you contend they had to have here?
So under 74-351 R5, expert means, and then it has the various standards. And so with regard to a healthcare provider, it's somebody that knows accepted provisions of healthcare to testify about those things. And so if you have a machine in the radiology department leaking radiation, you get a director of radiology to say, hey, you needed to have it checked more often. Or you get the director of a hospital who talks to the people, like the engineering type people who they hire, and says, you should have hired somebody to come out and check your machines. So it's not hard to come up with somebody muckety-muck at the hospital, hospital administrator type, or the director of a radiology department to say what they're saying. It's very easily solved in that fashion, and it doesn't even necessarily have to be a doctor because you've sued a hospital, and that's a hospital standard, not a doctor standard. Now, admittedly, if they had sued, say, a doctor, that would be different. You'd need a doctor to criticize a doctor, but that's not what they did. And then real quick on the distinction between Limestone and the other case, Stevenson, I just know that Stevenson cites a case that quotes Limestone has the right to control the progress, details, and methods of the work. And so to me, that's why they're holding hands. And so I don't think that's a big deal. And then the other thing in Stevenson that I think is important is if you look at all the testimony in Stevenson, everybody said the garbage truck driver that worked for Waste Management controlled how the helper guy that day who was injured, controlled how he did his job. And what testimony do we have about how he did job? He says they control the machines, but that's the sleight of hand. We have to control the workers for them to be our employees, not the machines. And so while we may control machines, that doesn't mean that we're controlling the employee like we're supposed to, or the person to be our employee. And that's what he's mixing apples and oranges on control. One last thing, and I'll sit down to give you whatever time left I have, is I would just say, he says that they were paid on the work units based on their production at the hospital by the hospital, but that's not what the evidence shows. The only evidence shows that's Shannon Clinic, and there's no evidence of how they were paid in the affidavits. Sorry.
Thank you, counsel. Case will be submitted. Marshal will adjourn the court.
All rise.
The 15th Court of Appeals now stands adjourned.
Do it again, brother.